applicant was one Susan Kiika Wakarura, and the parties are there. But the provisions, the part of the judgment that I want to refer to you without taking too much time of it, is that from page 7 to 8, where the question of jurisdiction is addressed by the High Court, we want to persuade you to apply the applicable principles or propositions which are made in this judgment. And, my Lord, Your Honor, you'd note that in the judgment on page 5, paragraph 30, there's a reference to the case of owners of the motor vessel Lillian versus Caltex Oil Kenya Limited, and the law report, relevant law report, is given a decision which has been unimpeached from the time it was made up to now, where the judges, and more particularly Justice Nyarangi, said, and this has been followed by the courts here, that jurisdiction is everything. You either have it or you don't, and if you don't have it, you down your tools. So we want to persuade the court that on this matter you are raising, we must down our tools. Downing tools is not taking away tools. It's not a sign of a derogation, but it's just downing the tools. And, Your Honor, the commentary by Justice Odunga in this matter, in paragraph 37, 38, 39, 40, and this is a matter in relation to a tribunal, and he was saying that even if the tribunal had to apply the Constitution, he can only apply that Constitution or interpret that Constitution in relation to a matter in which the tribunal had jurisdiction. So we are saying that this is a matter in which you do not have jurisdiction. Now, the other issue that we are raising, which I put out in summary, is that Chapter 6 of the Constitution is a very important creation and innovation in our Constitution, which talks to matters integrity, leadership and integrity. Now, under that chapter, Parliament is directed in Article 79 to enact legislation to establish an independent ethics and anti-corruption commission, which shall have the status and powers of a commission under Chapter 15. And my Lord, if you look at Article 249 of the Constitution, particularly 249.2, the commissions and the holders of independent offices are only subject to this constitution and the law, are independent and not subject to direction or control by any person or authority. There's a constitutional requirement that the commission shall not be directed or controlled. My Lord, if you look at Article 157 of the Constitution, which relates to the powers of the Director of Public Prosecution, it says in Article 4, Subarticle 4, the Director of Public Prosecution shall have power to direct the Inspector General of the National Police Service to investigate any information or allegation of criminal conduct, and the Inspector General shall comply with any such direction. So under our constitutional arrangement, the only person or office that the Director of Public Prosecution can direct or give orders in respect of investigations of a criminal conduct is the Inspector General. Now, unfortunately, for the Director of Public Prosecution, if you look at the charges in the charge sheet, they relate to offenses provided for under the Ethics and the Anti-Corruption Act. Yes, and Your Honor, just to address this point, the statute which talks to the creation of the commission by an act of Parliament enacted in compliance with Article 79 of the Constitution, Section 28, the Ethics and Anti-Corruption Commission Act, says, and it speaks of independence of the Commission, except as provided in the Constitution and in this Act, the Commission shall, in the performance of its functions, not be subject to the direction or control of any person or authority. So the case that we want to make, which is about abuse of process and lack of fair hearing, is that the Director of Public Prosecutions capriciously, malafides, and with ill motive has taken these matters to the Director of Criminal Investigations because he knows that that's where he can give directives as opposed to the Commission. And the proposition that we want to advance to Your Honor is that insofar as the chapter dealing with leadership and integrity in the Constitution and the enactment of Ethics and Anti-Corruption Commission is for purposes of dealing with matters that relate to corruption and the economic crimes, which we all agree must be dealt with. But because they relate to public officers and state officers in order to ensure that not every accusation that is brought on board is rushed to court. Offenses that relate to the Ethics and Anti-Corruption Commission are to be investigated by that commission. And they do that without direction from anybody. The of the commission in the Ethics and Anti-Corruption Commission is found in section 11, 1D. In addition to the functions of the commission under Article 252 and Chapter 6 of the Constitution, the commission shall investigate and recommend to the Director of Public Prosecution of any acts of corruption or violation of codes of ethics. So the Director of Prosecution was telling the commission, don't waste my time. I'm going to deal with this my way. But the law does not allow him to do it his way, because the Ethics and Anti-Corruption Commission Act has a full regime, code of law that relates to investigations, particularly to the offenses which are created under that act. Section 45, 46, and so on, are created under the Anti-Corruption and Economic Crimes Act. What is important in that? It is important, first of all, you would notice that the commissions are given the power of the police. They can investigate as to why the plea should not be taken. And right from the outset, for purposes of full disclosure, a petition has been filed this morning in the High Court. Petition 290.
May I say something? I agree. With great respect, I just want to say something to the court. Please. Your Honor, may it go on record that we have not been served with any application, and any application that is being made today, it's oral application.
No.
We have not been served with any
You should have listened to me. You should have listened to me.
They mentioned yesterday they were going
you should have listened to me. We have filed a petition in the High Court, not in this court. And I'm saying this for purposes of making full disclosure. That petition has been filed under the vacation rules for that petition to be had during the current. I was the one making the application. Yeah. Okay. Then. Yeah.
Yes.
Yep.
I was informing the court that my senior learned friend informed the court yesterday that he was going to raise objection to the taking of plea today, or objections to the charges that have been filed. And I was just informing the court that we have not been served with any application in any form since yesterday. So we are proceeding on the premises that the application that is going to be made before Your Honor is an oral application.
Yes, please. For the simple reason that we construed this to be a direct attack on the independence of the judiciary. The 2010 Constitution, for which we fought, for which we were detained, than people were assassinated, brought a regime into force in the country to protect the independence of the judiciary. Apart from the independence of the judiciary being protected by our Constitution, it is also protected by international covenants. The United Nations resolutions of 1985 do set out very clearly and emphasize that the judiciary must be protected, must be independent. In those provisions of the United Nations, there are provisions that relate to disciplining of judges for any misconduct. It's also emphasized in the resolution, the provisions of the United Nations, that those that are responsible to discipline judges must be independent. In our own Constitution, that has been provided for. We have Judicial Service Commission, which is supposed to be independent organ. And if there is any issue relating to disciplining of a judge, the Judicial Service Commission must be given the opportunity for its input. It will then recommend a tribunal to be set up by the President. When we come to the case of our Deputy Chief Justice, nothing of the sort was done. The Judicial Service Commission was not invited to make any finding or to hear her case. Your Honor, my humble submission is on this score alone, you must decline the invitation for you to take a plea in this case. Our internal provisions in the Constitution that protect the independence of a judge have been violated. My Lord, we also, Your Honor, we all want the issue of corruption to be dealt with. But that must be done within the framework of the Constitution. It must be tackled within the framework of certain provisions. Your Honor, if that is not done at all, we shall have rogues and crooks with power dragging our judges into courtrooms, dragging into our magistrates into courtrooms on trumped up charges, which have no meaning, which have no validity in law at all. Your Honor, judiciary is a very, very sensitive arm of the government. And it is imperative that if an individual, a judicial officer, is to be brought before this court, the provisions of the Constitution must be shown have been complied with. And the provisions are very simple. A tribunal has to be set up. A case has to be made out for misconduct. And if he's found guilty or is found guilty, then ceases to be a judicial officer And at that time, if the state wants to charge him with a criminal offense, can do so. Here we have Deputy Chief Justice, who is still enjoying the trappings of power. He's still the Deputy Chief Justice of the Republic of Kenya. She's entitled to her salary. She's entitled to police protection. She's entitled even to continue to sit as a Supreme Court judge. The whole thing is done in a very, very messy manner. That is not what the law is. And I would invite respectfully those who are dealing with the criminal law of the country, let them go back, let them sit down and read the constitutional provisions of the Kenya. Your Honor, may I emphasize before I sit down, with a tremendous respect, you have no jurisdiction to take me from this meeting at all. She is still the Chief Justice, okay? Let the Chief Justice thank. She is still sitting on Judicial Service Commission. Which has supervisory powers over you. I'm not saying it in a bad manner. Don't misunderstand me at all. Your Honor, at the bar and in our judicial system, we go by hierarchy. I am a mere advocate, nothing more than that at all. I'm expected to pay my respect to you as a magistrate. And you are a magistrate. You are expected to pay respect to a high court judge, or judge of Court of Appeal, or judge of Supreme Court. You have been put in a very embarrassing position. I would not like to be in your position at all. Your Honor, we are. Yes. Oh, Your Honor, I take note of what you have said. I do not wish to say much more. I would just like to say that it seems that certain individuals somewhere are trying to interfere with our independence of judiciary. One final word before I sit down here. I appeared in the case of Nancy Baraza. I was the lead counsel. Nancy Baraza was accused of a very, very trivial allegation. But she had to go. I again appeared in the case of Justice Rawar, who was set to become Chief Justice. It was an issue of age. We lost that case. And when I left the Supreme Court, I was a bitter man. I said a few things that should not probably have been said. Now, this lady has been brought here. Now, I want to say a few things here. This is a time when you say a few things. Just excuse me. Yeah. It seems that some people somewhere, when they want to change the judiciary, they want to change officers, they want to see themselves as chief justices or deputy chief justices, they go out to attack the women judges. She's a victim. Let us give us opportunity to argue this case before the High Court. And we shall demonstrate to the High Court of the whole country that these charges against this lady are malicious, vicious, spiteful, they have an ulterior motive. And there are certain individuals who are a party to it. They involve lawyers, advocates, they involve certain individuals and so on who want to have regime change in the judiciary. That is all.